Welcome, everyone. We're going to give it another few seconds to allow people to all join the Zoom room, but it's great to see you all.
Hi, Carissa. It's good to see you.
Hi, good to see you too.
I'll just give it another few seconds before we start. It's great to see lots of friends, familiar faces in the Zoom. Welcome, everyone. Why don't we start? And I still see people joining, but no one needs to hear my introduction. We want to hear from our speaker and our author. So I'm Brandon Garrett. I direct the Wilson Center for Science and Justice here at Duke Law. And we do work on reforming the criminal legal system, empirical work, policy work, and education work. We have a series organized by Melissa Boughton, our head of communications, called Novel Justice, where we feature really exciting new books in the criminal justice space. And we couldn't be more excited to have Carissa here with us. Professor Carissa Hessick from the Carolina Law faculty, talking about this book right here, Punishment Without Trial. There's no more important problem in our system today than how to deal with plea bargaining. And I hope you all get yourselves a copy of this if you haven't already. It's a wonderful read. It has really important insights and recommendations. And I'm counting on some of you, hopefully, who have read at least some of the book, to ask some questions. And so I have lots of questions, but I really hope that you all jump in and raise your Zoom hands or post questions in the chat. Either way is great. Whichever way you'd like to indicate that you'd like to chime in. We really like to make this as interactive as a Zoom event can be. So please, at any time, raise your Zoom hand, post something in the chat, and I'll kind of moderate and call on people. And you could ask your questions. Carissa can answer. Carissa's going to start by introducing the book and giving a brief introduction and kind of tour of part of it for a few minutes. And so we'll have the author read to us, and then we'll we want to hear from all of you. So please don't feel shy about jumping in. Raise your Zoom hands, post things in the chat, and thank you again, Carissa, for sharing and for writing this tremendous new book.
Thank you so much, Brandon. Thank you for inviting me to participate. I'm excited to do so from 10 miles down the road from you guys. This was a very, very, very sobering book to write. Unlike, I think, a lot of other things, at least that I've written as an academic, it didn't just involve me reading things and then writing them. It involved me speaking to a number of people, attorneys, judges, people who have been swept up in the criminal justice system, either as defendants or as victims. And what I wanted to do in this book was tell their stories and introduce people who aren't lawyers or who may be lawyers but don't think very much about the criminal justice system, to what plea bargaining is and how it affects people, and why we should all be concerned that that's the dominant method for dealing with criminal accusations in this country. So my plan, as Brandon said, is to read a little bit, a piece of the book, and then, but not the whole thing. So I'll go ahead and do that. I'll read for a few minutes here. I'm going to read a bit of chapter 3, which is called It's a Business Decision. Harry owned a small business that depended on investments. When the bottom fell out of the US economy in 2009, some of his investors lost money. One of those investors was friendly with an official at the Securities and Exchange Commission, the federal agency that regulates the stock market and other investment activities. After that investor complained to his friend, the SEC raided Harry's company over a holiday weekend, taking all of the company's computers and records, and those computers and records still haven't been returned. In addition to the SEC investigation, Harry and his partners were charged with fraud. Federal prosecutors threatened Harry and his partners with more than 200 years in prison. All of Harry's money had been seized by the government, and so he had to borrow money to hire a lawyer. Harry explained to his lawyer that he didn't do anything wrong. He didn't defraud any of his investors. It was just bad luck. Harry's lawyer talked to the prosecutors, but they were only willing to offer a plea deal of 20 years in prison. So Harry and his partners decided to go to trial. As the trial date got closer, the prosecution started to offer better plea deals. Harry and his partners kept insisting they hadn't done anything wrong. They'd followed all of the SEC rules and they hadn't defrauded anyone. So they wanted to tell the jury what happened. But their lawyer said that might not matter. He said that the jury was not going to understand the SEC rules. He'd seen juries who thought that defendants were probably innocent, but then they convicted on one count just in case. The lawyer explained to Harry that if the jury convicted on even one small count, he was still in big trouble. Even if you're acquitted of one crime, federal law allows judges to give you a higher sentence if they think you probably committed other crimes. For example, imagine a prosecutor charges you with both burglary and murder. The jury acquits you of murder, but finds you guilty of burglary. If the prosecutor convinces the judge that most of the evidence suggests you're guilty of the murder, then the judge will give you a very high sentence, probably the highest allowed by law on the burglary charge. Even though you won at trial, you'd lose at sentencing. Harry knew that if the jury acquitted him of most charges, the judge would probably give him the maximum punishment, or close to it, on any charges for which he was convicted. But he and his partners still wanted to go to trial. He knew that he was innocent, and as he put it, lawyers spend their lives convincing people to plead guilty. Harry's lawyer understood that his clients thought they were innocent, but he couldn't understand why they were insisting on going to trial, rather than just trying to negotiate the best plea deal possible. At some point, the lawyer was yelling at us, telling us we were ruining our lives, Harry recounted. "This isn't about guilt or innocence," the lawyer said. "It's a business decision." Finally, the prosecutors offered a deal that Harry felt he couldn't refuse. Although they had initially insisted that Harry serve 15 or 20 years in prison, when it became clear that Harry was willing to go to trial, prosecutors offered him a much better deal, only 2 years. Harry's resolve to take his case to trial began to waver. "You dream of going to trial and winning," Harry said, "but what do you really win? You win your innocence, but in a lot of ways you still lose. And if you lose at trial, then you leave your family with nothing." Even though he still adamantly believed that he was innocent of any wrongdoing, Harry accepted the plea deal. He had a good lawyer. He had a good case. His lawyer didn't even think that the things Harry had done were actually illegal. But Harry realized the inevitable. The deal was too good to pass up. Talking to Harry, I can't say he made the wrong decision. Based on the charges that prosecutors brought, Harry was facing up to 200 years in prison if convicted at trial. It's doubtful that a federal judge, would have imposed a sentence that high, but it was quite plausible that the judge would have imposed a sentence of 20 or 30 years if Harry had been convicted after trial. So it actually would have been irrational for Harry to have turned down the plea offer of only 2 years. And when I say it would have been irrational for Harry to turn down the plea offer, I literally mean that no rational person would have turned down that offer. The math just doesn't add up. It might sound strange, but we can actually use math to assess whether a defendant's decision to plead guilty is rational. We can do this by calculating what economists call the expected punishment. So you calculate a person's expected punishment by multiplying the punishment that the person would receive if they're convicted at trial by the probability that they would actually be convicted. For example, if I've been charged with a crime that carries a 10-year sentence, and there's a 50% chance that I'll be convicted at trial, then my expected punishment is 5 years, right? So that's 10 times 50%, which is actually 0.5. I'm sure you guys remember that from math class. That's how you get to the 5 years of expected punishment. If a prosecutor offers me a plea bargain that would require me to serve less than 5 years in prison, then I should take the deal. The idea of calculating expected punishment might seem crazy.
Hello, this is Marlene.
Whoops.
Oh, hi.
Holly's
What's up?
taking the call. Let's see. The idea of calculating expected punishment might seem crazy. After all, if I'm acquitted at trial, then I'll spend 0 time in prison. In accepting a plea deal, I give up my chance at acquittal, but at the same time, I've limited my risk of spending more time in prison if I'm convicted at trial. The idea of expected punishment treats going to trial as a gamble. You might win big or you might lose big. The plea bargain allows you to hedge your bets, and calculating expected punishment lets us evaluate whether the plea deal is a better bet than the gamble of going to trial. An expected punishment calculation tells us that Harry would have been irrational to turn down the plea deal. So let's assume that Harry was facing a 20-year sentence if convicted at trial, and he may have been facing even more than that. The plea deal required Harry to spend only 2 years in prison. 2 years is only 10% of 20 years. So even if Harry thought that there was an 89% chance that he would be acquitted at trial, it was still rational of him to take the plea deal. The deal allowed him to hedge his bet, and it was less than the expected punishment. Now, everybody in the criminal justice system knows that plea bargains are about defendants hedging their bets. If a prosecutor offers a good enough deal, a plea bargain with a sentence that's significantly less than the expected punishment, then a defendant would have to be crazy to turn it down. And that's actually what everybody thought about Joseph Taigano. They literally thought he was crazy because he turned down a plea deal and insisted on going to trial. Joseph Taigano and his father were arrested for growing more than 1,000 marijuana plants on their farm. Joseph's father pleaded guilty to a lesser crime, manufacturing 50 or more marijuana plants, but Joseph refused to plead. He sat in jail for more than 9 months waiting for a trial. When his lawyer postponed a court date without telling him, Joseph got angry and went on a hunger strike. The defense attorney responded by asking the judge to order a competency evaluation, which is a mental health screening to see whether Joseph was mentally capable of standing trial. The lawyer's request to the judge and the judge's decision to order the competency evaluation were based in part on Joseph's insistence that he receive a trial and his complaints that the trial hadn't taken place yet. The competency evaluation came back saying that Joseph was competent to stand trial. Because his lawyer wasn't respecting his wishes about scheduling the trial right away, Joseph asked the judge to let him serve as his own lawyer. The judge eventually granted Joseph's request, but insisted on appointing a new lawyer to serve as Joseph's standby counsel, which is basically a lawyer who can be there with you if comes to court with you and can help answer any questions or help with anything else if necessary. This second lawyer also thought that Joseph's continued insistence that he wanted his trial to take place right away was incredibly strange. And so she suggested another competency hearing, which also found that there was nothing wrong with Joseph's mental abilities. Despite his repeated pleas to hold his trial, Joseph sat in jail for years after that second competency evaluation. One reason for the delay was that the lawyers tried to negotiate a plea bargain. Another reason was that the government had failed to hand over some documents to Joseph and his standby lawyer. Crowded court dockets also contributed to the delay. And throughout this long delay, Joseph kept telling the attorney who was helping him that he wanted to go to trial immediately. That attorney responded by filing a confidential motion with the judge, recommending a third competency evaluation, saying that in refusing to plead guilty and insisting on his right to trial, Joseph was acting, quote, imprudently and not in his best interests. The prosecutor agreed that Joseph should have another competency evaluation, not because the prosecutor thought Joseph was actually incompetent to stand trial, but because he thought there might be, quotes, some other psychological problem that's going to prevent him from understanding the difference between what he potentially looks at as far as a conviction, as well as what's being offered by way of this plea. In other words, the prosecutor thought that something must be mentally wrong with Joseph because he didn't seem to understand that the plea deal he was being offered was so much better than what would happen if he went to trial. After sitting in jail for nearly 7 years, Joseph finally got his trial, and he was convicted. But he later got that conviction reversed because forcing him to wait so long for his trial violated his constitutional right to a speedy trial. Like Harry, Joseph was facing a much lower sentence by pleading guilty rather than going to trial. After he was convicted at trial, Joseph was sentenced to 20 years in prison, as compared to his dad, who was arrested with Joseph at the same time for exactly the same crime. He was allowed to plead guilty in return for a sentence of time served. And at that point, both the dad and Joseph had sat in jail for 4 years. So it's no wonder that his lawyer, the prosecutor, and the judge all thought that Joseph was crazy. If he'd pleaded guilty, Joseph would have spent only 4 years in jail. By going to trial, Joseph risked another 16 years in prison. And like the 200-year maximum sentence that Harry was facing, the 20-year sentence that Joseph was facing allowed prosecutors to place a lot of pressure on him. The higher the sentence prosecutors can threaten, the more it changes the expected punishment calculation in their favor. If I'm facing 100 years in prison if I'm convicted of a crime, then I'm going to jump at a plea deal of only 1 year. But if I'm facing only 3 years in prison if I'm convicted, then I'm more likely to go to trial if I'm offered a plea deal of 1 year. In other words, the longer the sentence is, the more leverage prosecutors have in plea bargaining. And the rest of the chapter tells us how it is that prosecutors got this leverage. It's a story about judges and it's a story about legislatures. It's not a pretty story, but I'll go ahead and stop there. Oh, I think you're muted, Brandon.
This is great. Thank you. Thank you. I see one wonderful question from Adele in the chat. Do you want to ask your question yourself?
Sure, I don't mind. I'm eating my lunch, so I was trying to keep my camera off, but
Sorry.
I can take a break from lunch for this. So I've been doing some work with plea bargaining, and one thing I've found is that people are typically pretty reluctant to talk about their strategies and their experiences, and even like the kinds of outcomes they've seen. It's almost like sorry, that's my dog. Chaos on this end. So they're often pretty reluctant to discuss it because potentially that could make it more difficult for them to get good deals for them in the future. And I've only really talked to lawyers about it, but I imagine it would be difficult for defendants too, because it would be stressful and so on. So I was just wondering how difficult it was for you to get all of those interviews for your book. And then if you think that this reluctance to talk about it and discuss it is part of the reason that plea bargaining is remaining a mystery in a lot of ways.
Yeah, that's an excellent question. I did have people who didn't want to talk to me for this book, or they were willing to speak, but they didn't want me to say who they were or give details about what they said because they were worried about how it might affect them. Harry, actually, the gentleman whose story I started with, that's a pseudonym. As part of his settlement with the SEC, he had to agree not to tell anyone about his case. My understanding is that there's an organization that's representing him to try to challenge that, which I think is actually a very common term in some of these agency settlements. I had, someone else that I wanted to interview, someone who spent 13 years in jail after pleading guilty to a rape that he didn't commit, and come to find out the law enforcement had a negative DNA test for him and still asked him to plead guilty. And his lawyer, so anytime I was dealing with a person, since I'm a lawyer, I went through their lawyers. His lawyers were very clear that he was concerned about retaliation from law enforcement. So there were a lot of people who didn't want to talk to me, some public defenders who would tell me stories about things that had happened in their offices and then ask me not to include them in the book. So you're right that there are people who don't want to say much. And I think the concern, part of it's for the lawyers, it's professional concern, especially to the extent that they worry that judges or prosecutors or other prosecutors in their office, if they're prosecutors or, whomever, might retaliate against them. But I also think you're right to the extent that they had strategies about defense attorneys had strategies about getting good outcomes for their clients. They were worried that more scrutiny of the plea bargaining system would lead it to be more harsh, and it would stop being a good tool for them to be able to get some leniency for their clients. I mean, one of the themes of the book is, especially when it comes to serious crimes, we have all of these plea bargains because the penalties are so harsh, and plea bargaining is the only way to try to get leniency. So it's an excellent question, and I'm sorry to hear about your troubles. And I was lucky to find some people who were willing to speak with me.
Great. We have a bunch of new questions. Karen, do you want to ask yours yourself, or do you want to go next? And then we have a question or comment from Kelly.
Yeah, listening to this, I'm going, why is an insane system bargaining with insanity? I mean, it's just, and again, I put the example, if what we were talking about is military people at war, as part of the war strategy to agree to go into a prisoner of war camp that the enemy set up for a certain period of time as part of the strategies that both sides were using for fighting this war. And nobody would want to have any part of that. It's the same thing. It's a different kind of war on people, but this kind of bargaining with human lives and souls, I understand why lawyers want to do it. I think it's probably part of how they I can't even say this, try and help their clients, because if people are innocent, this can never be a real help, because there's so many effects of incarceration on the individual and their family and the whole society. So it's really just not a help. If people actually committed a crime, then that's something else. But do you think that habeas corpus should be used more, quicker if there's a delay in trial? And as far as
habeas corpus is a big topic. That's a whole class.
And also the mental competency hearings. That's an invasion of privacy. It's obviously, I mean, after the first one, it's obviously that it's illegally done over and over again to this individual without cause.
Great, thank you. You want to talk about talk about the competency issue? And obviously, every time there's a guilty plea, the person is asked, do you voluntarily accept the consequences of this plea? And there's this assumption that the person has capacity to enter a plea.
Sure. So as Brandon just alluded to, before judges will accept a guilty plea from defendants, they'll engage in sort of an exchange with them where, among other things, they have to determine whether the defendant is entering into the guilty plea, sort of voluntarily, and whether they understand what's happening. I guess I always just find myself shocked and surprised that we think the fact that people have been threatened with more time in jail still makes the plea bargain voluntary. I mean, I think we have to change our definitions of words in order for plea bargaining to make sense. I think it's also really noteworthy that your right to a trial by a jury of your peers it's in the Constitution. It's actually in there twice. That's how strongly people felt about it. And yet what we do with plea bargaining, where we tell people that you will spend more time in prison if you make us go to trial and we convict you, we would never allow something like that when it comes to other constitutional rights. I mean, imagine that we had a system that said, look, you can go to the polls and you can vote for whichever candidate you want to, but if your candidate loses, we'll put you in jail later for 6 months. Everyone would say, oh, that obviously infringes on the right to vote. And yet we're willing to tolerate it when it comes to plea bargaining. And to be clear, this issue has been brought to the US Supreme Court, and their only response is, well, when we decided that we were going to say that plea bargaining is constitutional and it's permitted, we necessarily had to allow this sort of pressure to be brought to bear, because otherwise prosecutors wouldn't really have much to negotiate with and plea bargaining wouldn't work.
I guess one last add-on note is, right, one of the many rights that you give up when you plead guilty is the right to appeal or file habeas corpus, typically. And there are questions about how many of those rights you can give away, but normally, yeah, you can't file a post-conviction motion or an appeal. You can't file anything with very narrow exceptions, because that's part of what you're agreeing to. Those are some of the many rights that you're waiving, is the right to challenge the judgment once it's imposed.
Yes, so just really quickly, that didn't have to be the case, right? It could simply be the case that you agree to plead guilty, and then sort of over the decades, we've had these practices where we allow defendants to waive other rights, to sort of bundle these other rights together, including the right to an appeal or a post-conviction review. Exactly.
Vikram.
Sorry, I was taking myself off mute. So, Carissa, I've got the book, and I'm loving it so far, but I'm not all the way through it, so I'm sure you're going to answer my question somewhere in the book, but I'll go ahead and ask it right now. It's a question about solutions, because I agree with the diagnosis, but of course the solutions are the hard part. And it seems like part of the solution must just be that we need more trials. I know another part of it would be that we need less criminalization, but part of it's just going to be that we need more trials. And do you have any kind of an estimate of what capacity that would require? How many more judges, how many more lawyers, how many more law students and law schools to produce all of this? It feels overwhelming when you've got 97% of these cases not ever going to trial. Is there any kind of an estimate you could offer on what it would take?
That's an excellent question. Thank you, Vikram. It's very nice to see you. So the solutions part of this book is sort of it's a collection of things that probably won't happen. Like, America needs to think about how to solve problems with things other than the criminal justice system. But also some very sort of minor reforms that people probably wouldn't care about one way or the other, to deal with how plea bargaining happens in misdemeanor cases. The dynamic there is different, as I explain in the book, than it is for these more serious cases, because it's not the pressure of high sentences that drives plea bargaining there. It's the process of having to come back to court all of the time and how disruptive that is. So that problem, I think, is actually solved in a much easier way. But the capacity problem that Vikram asks is a great one, because before I started working on this book, I thought, oh, we have plea bargaining because we just don't have the capacity to have trials. And so there's this big capacity question looming out there. And as I sat down to do the research, one of the judges that I interviewed for this book, Judge Goodwin, he's a federal district court judge in West Virginia. He has been very outspoken about plea bargaining practices in federal court, especially in his courtroom in opioid cases. And he started asking the government about their plea bargaining cases. He asked them to explain why they were plea bargaining everything, and they told him, capacity, we don't have the ability to bring these cases to trial. And Judge Goodwin, who's been on the court for a very long time, was like, well, that's strange, because when I first became a judge, there were more trials. And when I first got out of law school and started practicing law, there were even more trials. And so he dug into the capacity question, and he found something that I just think is absolutely shocking. And what he found was that capacity he's talking about the federal courts. So I'm going to limit myself to the federal courts. The capacity in the federal courts has gone up significantly in the past 20 or 30 years. So he had data starting in 1990. And then I think his last year of data was 2016. And he showed that back in 1990, there were almost 8,000 federal criminal trials held that year. And in 2016, it was less than 2,000. So we have a quarter of the trials now that we did 25, 30 years ago. And we have significantly more prosecutors and significantly more judges. So Vikrant, it's true that in order for everyone to have a trial, we would need to increase capacity substantially. But right now, capacity is not driving what's happening. I think we have a culture of plea bargaining and just the stakes are too high for defendants. We could, at a minimum, bring ourselves back to 1990 levels of trial, and we could do more than that because we have even more capacity than we used to. So I think the answer is we should obviously look into what it would cost to try every case, but the argument that we have to give prosecutors this sort of leverage because we couldn't possibly deal with the trials of everyone who wanted to go to trial, that's actually just, the numbers tell us that argument's wrong.
Great. Well, we have lots of hands up, lots of questions in the chat now. Dan Simon, do you want to go next?
Sure. Hi. Thank you, Carissa, for this, and I'm very much looking forward to the book. One of the arguments for sustaining the accuracy of the process is the adversarial trial, cross-examination, the greatest engine invented, and all the rest. You could imagine that a cop who's doing an investigation might be thinking, well, how is this going to be looked when it's scrutinized in court? Come plea bargaining, it basically means that it rarely, if ever, does. So how would you describe that sort of dynamic relationship between the lack of a trial and not that I think that the trial is such a guarantee for accuracy, but still, the idea that nobody's ever going to look at this closely.
Oh, Dan, I think you're entirely right to highlight that. And one of the attorneys that I interviewed for the book and shadowed him in court for the day, he identified how this affects police behavior as one of the things that he found most troubling. So he talked about how, pressure at plea bargaining leads to the fact where his clients, can't take the gamble of trying to file a suppression motion, right? They'll have to, if they file a suppression motion, the plea bargain goes away. And he tells this story about a client who was stopped by police, and there was an improbable story by police officers about the stop and about the search that they conducted. And nonetheless, the defense attorney is explaining to his client how he should take the plea deal, and the client wouldn't take it. Like, the client was like, definitely not, I'm definitely not going to. And he's like trying to convince his client to take the plea deal, and the client won't take it. So they go to the suppression hearing, and the police officers do horribly on the stand, and the judge suppresses the evidence. And then it's like this, it's like, oh, what a sort of happy outcome, right? It sounds like there was some illegal conduct by police officers. It got suppressed. The client got to go home. That's how the system is supposed to work. And then he followed up by to say that a month later, he was back in court with the almost identical set of facts, the same prosecutor and the same police officers. And that client's like, yeah, no, I'll take the deal. So his point was, plea bargaining shields any sort of consequences for police officers. And it's, by the way, it's even worse than you think, because when police officers engage in really outrageous behavior, not simply behavior that might result in, the suppression of illegal evidence, but like violence towards citizens, plea bargaining is actually used as a way for the state to make any possible civil claims go away. So as Brandon was saying, you get to you get to bundle all of these other rights that people waive. They'll waive their rights to a civil suit in return for a non-prosecution agreement, or in return for a plea bargain to much sort of lesser charges. And that ends up having really terrible systemic consequences. One of the chapters in the book is about civil forfeiture, and about how plea bargaining and the threat of criminal charges basically allow some local governments to, there's really no better word for it, steal from people who drive through their jurisdiction.
I would love to talk more about the civil forfeiture parts of the book if we have time. Ben.
Yeah,
Thanks, Brandon. Oh, there
sorry.
are two Bens.
Oh,
I can hold. Go ahead.
Go ahead. Go ahead.
All right. So I'm wondering, I'm with Vikrant. I haven't finished yet. And so maybe you've answered this, but I'm wondering to what extent you think just lower penalties altogether are a viable solution.
So lower penalties would go a long way towards alleviating some of the pressure that I mentioned, right? Let's be clear. I don't think that we can use the rational actor model to explain life generally, or what happens in the criminal justice system in particular. Like, my apologies to Judge Posner and others who think so. But even rational people, when the penalties are high enough, will take a plea bargain, will plead guilty, even to things that they haven't done. So there's no doubt that lessening the penalties has to be part of the conversation, especially once we realize, and I have some examples of this in the book, that when legislatures sit down to write laws now, they write those laws against the backdrop of plea bargaining. So there will be open discussions in committees about how the penalty has to be set at a certain level so that prosecutors can get people to plead guilty. There's an excerpt in the book about a conversation in Congress when the Senate decided to revisit the mandatory minimum sentences for drug crimes, and there was a bipartisan coalition of senators who decided that the sentences were too high. We didn't have to have 5 years as a mandatory minimum be what we set for relatively low level dealers. And they pointed to the fact that so many, sort of drug mules and not particularly culpable people are caught with that amount of drugs. And Senator Chuck Grassley was like, oh yeah, but if you look at the data from the US Sentencing Commission, you can see that those people are mostly being allowed to plead guilty to something else. So the system's working the way it's supposed to. So in my mind, once we realize that these laws have been written literally to pressure people into pleading guilty, then it's very hard to argue that what plea bargaining is about, sort of letting people off the hook. It's actually not. We've created a system where we actually give people the amount of jail that we think is the appropriate time. We just coerce them into not having a trial before we do that.
Next, Kelly. I'd love for you to talk about the point you're making in the chat about trying to bring more research to the attention of judges.
Yeah, hi. Thanks for hosting this. This was at the very beginning when you were talking about sort of the rational actor. I was saying that we recently published a paper showing that if you incorporate guilt status into shadow of the trial model, it has more predictive validity in terms of plea decision making. So I'm curious how we get that type of research in front of judges, especially this judge who wanted, multiple competency evaluations, things like that, so that we can move away from that type of black and white thinking.
Yeah, so let me say that I don't, as a general matter, think that judges are the hero in this story. I mean, plea bargaining and sort of overwhelming guilty pleas, that all happened because judges would get annoyed when people would go to trial and they would hand out larger sentences. So in some ways, sort of judges probably got us started down this path. That said, I think that there are many judges who are incredibly concerned about where we are now. I mentioned Judge Goodwin, that federal judge in West Virginia. There was a judge in Ohio in Cuyahoga County who was actually so concerned about plea bargaining that he ran on a platform of plea bargaining reform and was elected to the Ohio State Supreme Court. So I do think that there are some judges who want to pay attention to this. They're concerned that all of the decisions are being made by prosecutors, and they're concerned about, you know, where we are right now in the system, that defendants don't seem to be able to get a day in court, even if maybe they should. So, I mean, how do we get it in front of the judges? I actually think when academics talk about things, judges try to pay attention. I think that there are more avenues that we can use to get there. I mean, most judges, they have conferences where they get continuing legal education. You know, the federal judges sometimes are a little bit easier to figure out where they get their education from. The Federal Judicial Center does a lot of that work. In the states, you have to probably talk to the folks in your state. I know the chief justices of all the state Supreme Courts, they have a big annual conference. So frankly, I think that academics, we should be a little pushier, right? And maybe we could do a better job of trying to come up with this information, and then maybe as a group, trying to send them information about the sorts of topics that they should consider. You know, 20 years ago, Brandon knows more about this than I do, right? When judges, all of a sudden, some of them were starting to see DNA evidence in their courtrooms. And what did they do? They brought a bunch of people in to train them on forensic science. Now, we could probably have a lengthy conversation about how good that training was and where it left them and the decisions that they ended up making. But the truth is, I think judges are highly motivated to learn more about certain issues and to make sure that they're making correct decisions.
Next, Will, and then Allison.
Hi, Carissa. So this book was my birthday present this year, so I haven't quite got all the way through it yet. But I was very excited to see it out. I'm really excited to hear you talk about it. I think my question is maybe really a good follow-up to Kelly's question just now. And like, you know, you, especially the excerpt that you read, you know, you talk about how there's rational decision-making and how we can calculate these things and make these rational decisions. And it sounds like that sort of approach is kind of built into how actors like judges or prosecutors, even defense attorneys, are thinking about the decisions. But the other side of that, I think, is that like we know that that's not how people make decisions, right? Like the follow-up to that work is that people make irrational decisions all the time. And specifically in a way that I think somebody put in Bruce Burnett put in the chat, like, you know, there's other calculations that go into there. And so I guess maybe a two-part question, or, you know, kind of take which one you want to address is, in your work for this project, is there any kind of acknowledgement of that irrationality? And then kind of further on that is like, that seems problematic to me, or like, right, it seems problematic that we think about these sorts of things as rational or irrational, as opposed to maybe something like sentence focused or risk averse, or like those sorts of things. So I'm curious if you came across any of that in your work, or like any thoughts on kind of maybe reframing those approaches, if that would make a difference.
Sure. Excellent question. And yes, I completely agree with you. People are not rational human beings. I'm not a rational human being. I love all of those experiments that the behavioral econ people do to show that we're irrational, even in predictable ways. But the very next chapter, so chapter 3 is all about setting up sort of the framework and the leverage. And chapter 4, which is largely a chapter about pretrial detention, the message there is very much that people are not rational. It opens with a story from now a former public defender in the Bronx. He told me that he never saw anyone turn down a plea deal that would let them go home that day. And he has this really compelling story that I tell in the book about someone who was out on supervised release from the federal system and was clearly facing months and months and months in prison. And it was, he was going to plead guilty to something that would clearly get him in trouble on his supervised release, or have to spend 2 more nights in jail to try to get a better resolution. And he chose to go home right then. which sounds crazy. Obviously, even with like, you know, present sense discounting or whatever that stuff is called. I'm not an econ person, as you can tell. You know, eight months in jail is so much worse than 2 more days in jail. But as Michael Block, the now former Bronx defender, told me, he's like, look, I'm not in a position to say that I could have made a different choice, because jail is just a horrific place. And the chance of going home right away, that's one of the big things that really pushes misdemeanor cases through, among other things, one of the things that pushes misdemeanor cases through the system. So we have every reason to think that people aren't rational actors about these things. And even if we did think that they were rational actors, we don't give them the tools that they would need in order to like actually make those sorts of decisions. And there's lots of evidence that the prosecutors aren't rational about these things. So my goal is to try to present the stories and the arguments for people, no matter what their persuasion, right? If you're a Gary Becker, like law and econ type, this book should tell you that plea bargaining is wrong. And if you're more of like a touchy-feely, like social scientists have shown that people have complex decision making and they're often going to be irrational, this book is also going to tell you that it's wrong. Hopefully the whole book is just going to make everybody be like, oh my God, this is such a disaster. We need to stop doing this, no matter what your sort of prior sort of thoughts are about human nature or politics or any of those things. That the reason I wanted to write this book is I was just like, this is such a train wreck, and no one that I've ever spoken to, once I could figure out sort of what their priors were, has been like, yeah, no, we should keep the system.
Great. Allison.
Yeah, thank you, Carissa, for writing this book. I'm sorry I don't have my camera on. And I really do look forward to reading your book, but I have not read it yet. I'm very excited to. My question is about evidence. I mean, we talk so much about all of these other factors that lead to coercion, and, you know, we talk about pretrial detention, and we talk about, you know, the disparities between the plea discount and the trial penalty. And these are things that, you know, we can measure, if, you know, if not perfectly, at least imperfectly, we can measure them in these kind of administrative databases and things. But what we can't seem to measure is evidence. And so I guess my question is, you know, did they talk about evidence at all? And, you know, is it, you know, if you look at some of these surveys that were done in like 1980 or something, you know, they asked prosecutors, what's the most important thing in plea bargaining? And they said evidence. Mm-hmm. But it seems like evidence has been pushed aside for all of these extra legal factors. And my kind of sub question to all of that is something that I'm really interested in, is kind of the differences in the quality and the quantity that of evidence at the plea bargaining stage versus evidence at the trial stage. It's kind of like, this person's not going to accept a plea bargain. I have to prove my case beyond a reasonable doubt now. So I better go collect more evidence. I better look at the reliability of evidence, which we know in so many ways is often poor. So I guess, what did people have to say about evidence?
Yeah, that's an excellent question. I'm so glad you asked it, because, you know, the academic model of plea bargaining is, you know, the expected punishment calculation that I mentioned. And in order for people to estimate the likelihood of conviction, they have to assess the evidence that would be introduced at trial. And I'll tell you that in misdemeanor cases, it's pretty clear that the plea bargaining goes on without much attention, either by prosecutors or defense attorneys, to what the evidence is. They do things very quickly and they don't do investigations. And then that's why, as trial dates come closer, as it did in Harry's case, sometimes you get a much better deal from the prosecutor because they'll realize that there's a huge flaw in their case. Other times the opposite will happen, right? They'll have offered a plea deal and then they're like, okay, if you're not going to take this, then we're going to take the plea deal away and we're going to work up this case. And now, you know, if you're going to come back to us, the deal is going to be worse. But probably I have to say the most disheartening thing that I learned in this book, in doing the research for this book, is what happened in a state where they actually tried to make sure that evidence was available to defendants before they had to make plea bargaining decisions. And that's what happened in Arizona. So Arizona instituted what a lot of people call open file discovery. Basically anything that the prosecutor and that the police have has to be turned over to the defendant. It's not, you don't have to wait like you do in the federal system or like in New York or a bunch of other places for the trial date to approach. They just get it right away. And in Arizona, the right to discovery is triggered by indictment. And so what prosecutors in Phoenix have done is they've repurposed their diversion courts. So they're like problem solving courts that are supposed to be like, we're going to bring you in, we're not going to indict you, we're going to try to come up with a, get you into treatment type plan, and we'll do that as an alternative to the court system. What they do is they bring all of their cases there, except I think not homicides, and I think not rapes or kidnappings, but other than like sort of the absolute worst cases, every other felony, every other misdemeanor, they get cycled through these courts where the defense attorney gets a copy of the police report the night before the appearance. They show up, the prosecutor tells them what the plea deal is, and they tell them that they have 30 days to either have their client plead guilty or they will indict them and they will get no further plea bargain from their office. So what have they done? They've made an end run around the legislature's requirement that they hand over all of the discovery by having these exploding plea deals and bundling everything into it, including the right to discovery. And the results, as you might imagine, is everybody pleads guilty before they get their discovery. And one of the defense attorneys that I talked to for the book, this public defender in Phoenix, she'd say like, look, I'd have to go to the prosecutor and I'd say things like, my client says it really wasn't him in the liquor store holdup. Can you please check the tape for me before the 30 days expires? Not can you show me the tape, but can you please look at the tape and see if you agree that it doesn't look like my client before I have to tell him that he needs to plead guilty. So the upshot of all of this, sorry, it's a long way of saying evidence should be important. And yet it ends up not being. And yes, I see the comment in the questions. It is in Maricopa County. And yes, I know the ACLU has brought that lawsuit. I'll be very interested to see what happens.
Great. When we go back, so the other Ben Rossi, please jump in now. You asked about like, what do we know about plea rates around the country in different jurisdictions?
Yeah, so thanks for the talk and for the book. I just wanted to know if there are significant differences in plea deal rates between the state and federal levels within different states or for different crimes, and if so, why?
Oh, that's an excellent question. And the truth is we don't have good data on this. Like we have decent data from the federal courts, just because, sort of the administrative office of the courts and BJS and those sort of agencies keep track of things. But the truth is we actually don't even have guilty plea rates from, I can't remember if it's 23 states or 27 states. So we really only have the data from about half of the states. We don't know from the others. And I haven't sat down to try to disentangle what the plea bargaining looks like in different places. I have to say, I would be like, I wonder if Brandon's looked at that, because as you guys probably know, the Wilson Center is doing an awful lot of really excellent research on plea bargaining. So that might be something that they've looked at in the jurisdictions where they're working with prosecutors to shine a light into what happens in plea bargaining. But I didn't look at that data. I didn't look at that data for this book. And I was actually just sort of appalled to see that we couldn't even tell what the plea rates were in basically half of states. And I see Allison has something in the chat there saying that she's recently written a chapter about it. So I'll be emailing her to follow up, and maybe you should too.
Yeah, at least some of the places where we're doing work, there isn't good data on plea rates or what happens during the plea process, which is precisely why we're doing the work. It is because so often, I mean, in states with sentencing commissions, there tends to be this kind of data. And then there's states like Ohio where there's a sentencing commission that itself doesn't have data, and it keeps going to the lawmakers saying, like, please, like, we'd like to be able to report on something real. That's what commissions normally do. Like, why can't you give us the authority and the ability to collect the kind of data we need to answer basic questions? Danny Spiegel, I think we have time for like one, maybe two more questions.
Hi, Professor Hessick. I'm Danny Spiegel. I'm in the DA's office in Durham. I'm policy counsel here, and I've been a prosecutor for coming up on 3 years, and I was a public defender for 8 years. I've only read about a third of the book, but I found it to be a scathing indictment, very, very persuasive, very troubling. I think the most egregious anecdotes, fortunately, we can kind of dodge in Durham, but we're certainly not above reproach when it comes to kind of the overall policy. I have a lot of thoughts, and I'd love to talk to you more about it in the future. But the two things I thought I would bring up with only a few minutes, I was wondering if you ever encountered any formal policy or any kind of in writing or kind of informal idea where prosecutors are deliberately limiting the trial exposure. That's something that we talk about in our office a lot, but kind of the deliberate kind of limiting trial exposure so that the disparity between the trial and the plea is not so egregious. We worked a lot of that during the transition, and we had some various input, but in practice, it's very difficult. And it's something that individually, some of us in the office certainly take very seriously and try to incorporate into our practice, but the culture is so intransigent that it tends to push back against that. That was the first thing I wanted to ask, if you've encountered any kind of policies that specifically contemplate that. The second thing I'm wondering, and I haven't gotten to the last chapter in terms of the solutions, but I'm wondering if you talk about something which is kind of not popular, certainly for defense lawyers or for people that talk about all the wonderful constitutional rights that we have in this country, but just the immense technical burden that trial now has. And just a brief anecdote, a few weeks ago, I had a case involving some surveillance video. And I think we all like to think that we're seeking the truth, but merely getting the surveillance video into evidence is not a foregone conclusion, because it requires a community member to potentially want to testify just to simply set a foundation, and that person may be afraid of various gang activity or retribution. So that's one thing I didn't really realize until I switched sides, is how elaborately difficult the trial can be, even after 8 years of defense work. So I'm wondering if you talk about the inquisitorial system and whether there are thoughts about kind of less elaborate trials as a potential solution.
Yeah, so thank you, and I'll answer that question one second. I know some folks will probably be popping off, and I just wanted to put the link to the book in the chat for anyone who hasn't had a chance to take a look at it. So thank you so much for the question. It's nice to talk to you. I'm always excited to talk to folks who are in offices where there's this sort of thoughtful attempt at reform. In terms of policies that I saw, I interviewed folks from a couple of different offices. I interviewed Rachel Rollins up in Suffolk County, Massachusetts, and one of her major deputies. I spoke to the new Arlington prosecutor, Carissa Hessick, whose last name I believe I'm mispronouncing. And among the things that they said was actually the bail policies that they had adopted were a big step towards changing plea bargaining culture in their office, because by having an office policy, and this is especially down in Arlington, having an office policy where they weren't permitted to seek bail. They either had to argue in favor of somebody being detained pre-trial with very explicit explanations of what danger they posed, or they had to support release with non-financial conditions. That made a big difference in their office. The other thing that happened in their office was they had rules about if you had doubts about being able to prove a case at trial, you weren't supposed to give a better plea bargain. You were supposed to dismiss the charges. And so I talk about this a bit in the end of the book. It's easy to say that the antidote for too much plea bargaining is more trials. I actually think another major approach has to be more dismissals. Prosecutors need to act as gatekeepers on the front end to take more cases out of the system, the cases that they don't think that they could prove. It might, at the end of the day, leave more resources and more time for the complicated cases that you're talking about. You know, I know that there's a big conversation going on in this country right now about abolishing prison. Some people that I admire very much, that's sort of where their sympathies lie. That's not where my sympathies lie. I think we need a criminal justice system. I think there are serious crimes that need to be deterred and that need to be punished. And I guess I'm just hoping that we could build a system that's able to deal with those crimes better than we do now, because the truth is, it's easy to talk about how the system is too harsh, but it's also really easy to go and collect a bunch of stories where we had some pretty serious wrongdoing and not enough attention paid to it. And I would say not sufficient consequences either.
This is fantastic. We have to close out our hour. But to answer one question in the chat, and there's a flurry of wonderful questions and responses and activity in the chat, this recording will be available. It'll take a few days. It'll need to be closed captioned by Duke to make it an accessible video recording, but we'll make it available to everyone who couldn't attend in person. I know many of my students wanted to be here for this. But please read the book and keep all these questions and answers in mind if you haven't read the book yet as you're reading through it. And thank you again, Carissa, for sharing. This was really a treat.
It was my pleasure. Such an engaged audience. I really appreciate it. Thank you all so much.
Take care, everyone.